You have now reached the point in your family law litigation or collaborative process when the time has come to mediate. Perhaps the court presiding over your case has ordered you to attend mediation, or perhaps you are mediating by agreement. Either way, you should consider your upcoming mediation a positive opportunity and an excellent tool for potentially resolving your pending family law matter without having to go to court. The purpose of this presentation is to provide you with some basic information regarding the process of mediation, as well as helpful hints designed to assist you in participating in what we hope is a productive and successful resolution of your family law case. Mediation is a process where the parties in a pending legal matter attempt to settle their case in a confidential environment, aided by the active participation of a neutral third person referred to as a mediator. Although different mediators use different approaches and methods, most mediators will utilize the information provided to them by the attorneys and the parties participating in the mediation, combined with the mediator's own knowledge of family law and knowledge of the court in which the case is pending, to assist the parties in an attempt to reach a settlement of all or a portion of their case. You should not be fearful of your mediator or the mediation process. The purpose of mediation is to help you and the opposing party reach an agreement. The mediator may accommodate communications and consensual information exchanges between the parties while providing the parties with wisdom, potential settlement terms, and creative ideas and solutions for their consideration. But the ultimate decision is yours as to whether you will make or accept an offer. The mediator is there to help you, not to force you into a possible resolution of your case. So don't be afraid to mediate.
Okay, folks, we have our agreement here, and we're going to need some signatures, please.
Okay.
An agreement reached at mediation is generally referred to as a mediated settlement agreement. Mediated settlement agreements are called MSAs for short. You'll likely hear this term frequently during your mediation. If you do reach an agreement at mediation, you will be legally bound by the terms of that agreement, and it is very, very difficult to set aside. So make sure that you completely understand every term of the agreement and that you are prepared to be totally committed to those terms before you sign it. You won't be able to make changes later. Your mediation may take place at your attorney's office, the opposing attorney's office, the mediator's office, or some other location. Each party and their attorney will have their own room, allowing privacy for discussions and meetings with each other and with the mediator. Generally, you will not be required to be in the same room with the opposing party at any time unless everyone agrees to do so. Dress comfortably for your mediation. You may be there a while. Some mediations last just a few hours and others may last all day or longer. And bring a sweater or jacket just in case the temperature is colder than you prefer. Don't dress too warm either. You want to be comfortable during your mediation so you can focus on trying to settle your case and not be distracted by discomfort with your clothing or environment. Bring something to keep you occupied, such as your laptop, a book, or magazine during downtimes when you're not conferring with your counsel or the mediator. Sitting alone in a room with nothing to do can add more stress to an already potentially stressful time. If your mediation is scheduled to last all day, lunch will likely be provided, and the office where your mediation is taking place will probably also have snacks and drinks available. However, if you're a picky eater or have a special diet, bring some snacks just in case. Again, your comfort, both physically and mentally, is an important part of a potentially successful mediation. Be aware of your surroundings and the location of the opposing party's room. You may be in close proximity, in which case it's a good idea to keep the volume down. Loud discussions can be misconstrued, and even a simple misunderstanding could hinder the productivity of the mediation process.
There is no way that I will ever agree that she gets the house. That's not going to happen.
Okay, keep it down.
I'll tell you what else.
Keep it down. What was that? What's he yelling about? I thought we were here to settle this. I am not doing this.
Wait, don't go. Look, don't leave. There's no reason to leave.
So be aware of the proximity of your mediation room to that of the opposing party. Besides, it's always courteous to speak in normal tones. Mediation is a confidential process. Your mediator is bound by rules of confidentiality and cannot convey to the opposing party information that you have indicated is confidential unless you have given permission.
So let's talk about some possible settlement terms and how we might be able to get there.
It's okay. You can tell the mediator your terms of settlement and he won't tell your wife. What happens in this room is confidential unless you say otherwise.
Good.
Although you and your lawyer can decide what you may ultimately discuss with the mediator and what should or should not be conveyed to the opposing party, you should not be concerned about discussing information with your mediator that is necessary for your mediator to better understand your desired terms of settlement. It's also very helpful to the mediator to understand the underlying facts or allegations that are motivating those desired terms. Your mediator needs this information in order to better aid him or her in assisting you in a potential settlement.
You guys ready to talk?
Yep, we're ready.
All right, now that we understand that mediation is confidential, let's talk about the process itself. Once the mediator has advised you of the rules of mediation, the mediator will probably want to hear about the history of the case and what issues are most important to you. The mediator will also want to know what are your most important goals of the settlement and why. Be sure your mediator knows what you want and why you want it. This information is designed not only to enhance the information the mediator has already obtained through pre-mediation information request, but also to help the mediator to get to know you personally and to help you negotiate for the things that are most important to you.
So I want to talk to you about a few rules of mediation and then talk to you a bit about your case, what you want and why.
Prepare yourself in advance to provide this information in a succinct manner that will allow the mediator to get to know you and the facts of the case as you see them. Most importantly, let the mediator know what you want in your settlement and why you want it. You may be limited in the amount of time available to you to do this, so prepare yourself in advance, and when the time comes, stay on point, stick to the task at hand. As time passes during mediation, you and your attorney will have other opportunities to provide more specific information and insight to the mediator. Once the mediator has had his or her initial meetings with all of the parties, the mediator will usually then determine which party will make the first offer. Sometimes this is predetermined based upon the party designations in the case. For example, some mediators have the petitioner make the first offer to the respondent. In other instances, one party may want to make the first offer, or the other party may not want to make the first offer. Each case is different, and each mediator is different. Most mediators will use their skills and experience, combined with what the mediator thinks will work best for the specific parties to each case, to make this determination.
Let's put together the first offer.
All right. We know your desired outcome, so let's decide where we want to start.
Let me get my notes.
Okay?
This video is not intended to provide information or instruction regarding how you or your attorney should prepare for your mediation negotiations or strategy, but rather to provide you basic information regarding the process itself. However, it's logical to assume that the mediator can maximize his or her assistance to you and your attorney in putting together reasonable offers, coming up with creative settlement ideas, and crafting responses to the opposing party's counteroffers, if he or she has the necessary information to do so in advance. So please, come to mediation prepared, and come with at least your first proposal prepared in advance, so you don't waste precious time in mediation. Your mediator has probably provided you and your attorney with an information sheet requesting certain information essential to not only a potentially successful settlement, but also to assure the best use of your time during mediation. Your mediator may have also requested certain documentation to aid in the mediation process. For example, if you're attending a mediation for your divorce, your mediator may have requested you provide a list of your property, sometimes referred to as an inventory and appraisement. Your mediator needs this list in order to prepare in advance for property division discussions. So please, be diligent in assisting your attorney in gathering the documentation requested by your mediator. Preparation and organization in advance of mediation is always a wise strategy. Your time at mediation is better spent discussing and negotiating settlement terms based upon information that has already been compiled, rather than spending valuable mediation time compiling that information during the mediation itself.
You never brought me that list of property.
I'll get started on that right now.
Okay, are we ready to talk about property division?
We're still working on that. We'll have it ready for you in about 30 minutes or so.
Okay.
Your mediation time is limited. You should use it wisely. And one way to do so is to come as prepared as possible and to not utilize valuable time preparing when you could be mediating. Another significant piece of information to have completed before you arrive at mediation is a list of your desired settlement terms. Be prepared to let your mediator know specifically what you want and why you want it. Your lawyer can assist you in putting together a clear idea of your bottom line. This information is invaluable to a productive mediation.
Let's get started.
We're ready.
Here are a few more helpful hints and information about your mediation. If you want to talk to your lawyer outside of the mediator's presence, don't be afraid to ask the mediator to leave the room. This is a normal part of the mediation process, and the mediator understands that there are going to be things that you want to discuss with your attorney privately.
Could you give us a moment, please?
Of course. I'll step out and let me know when you're ready to continue.
There may be times during the mediation when the mediator determines that it would increase the potential of settlement of the case for the attorneys and mediators to meet separately outside the presence of the clients.
Counsel, why don't you come with me and we can talk to the other attorney about this spreadsheet?
Sure. I'll be right back.
During the negotiations, the mediator is going to be working with each party and that party's legal counsel to assist them in crafting offers and counteroffers to propose to the other party. This process may go on for some time, and several offers, counteroffers, and additional negotiations will likely take place as the mediation progresses.
All right, folks, we've got our first offer. Let's go over it. Your husband is offering a joint managing conservatorship, and he is proposing that you have parenting time with your son on the weekends beginning at...
No. I'm not visiting my son on the weekends. I told you I would not agree to that. No way.
Hold on. Let him finish.
I'm not doing that.
Let me tell you the rest first.
Always let the mediator finish reading the offer before you respond to it. Interrupting the mediator when the mediator is conveying an offer is not productive. It interferes with everyone's concentration on the task at hand and can hinder your ability to focus on the remainder of the offer. And you may find out, if you let the mediator finish, that although you may dislike that particular portion of the offer, the entirety of the offer is not as bad as it sounded when you interrupted. A good rule of thumb is to try to respond to the other side's offer instead of just reacting to it.
As I was saying, your husband has proposed in his offer that you have parenting time with your son on the weekends beginning at the time school is out on Thursday and continuing until the following Monday. And then he will start his parenting time on Monday and continue until you start again on Thursday. It actually works out as 4 nights for you and 3 nights for him.
Oh, well, it's not as bad as I thought it was, but I still don't like it.
Well, let's go through the rest of the list.
Let the mediator finish reading the offer. Then you, your lawyer, and the mediator can go over each item and determine what you might agree to, what you won't agree to, and what to include in your response. Keep in mind that your mediator is also receiving confidential information from the opposing party's mediation room. Because of this, your mediator knows things that you and your lawyer probably do not know. Your mediator will take this information and attempt to formulate settlement ideas based upon your respective desires and interests. So give careful consideration and attention to your mediator's ideas, keeping in mind that these ideas are likely based, at least in part, on your mediator's knowledge of what each side desires to settle this case, and each side's respective bottom line for settlement. And although all mediators are different, and we're not here to address the experience or expertise of all mediators, generally it's likely that your mediator is not only a trained and certified mediator, but is also experienced in family law. One of the most important rules of mediation is that the parties are required to mediate in good faith. This means that you appear at the mediation with the intent of making a good faith effort at settling your case. Mediation is never to be intentionally used for any untoward purpose. For example, it's not good faith to attend a mediation with the intention of seeking information for later use in litigation while having no intention of actually settling the case. Although mediation is a confidential process, the requirement of good faith is such an important tenet to the process that the mediator is allowed to convey to the judge that a party was not mediating in good faith. You're required to mediate in good faith.
Well, thank you so much.
And thank you so much.
You're very welcome.
I appreciate us not having to go to trial. Thank you again.
Thank you.
We hope that you're able to resolve your case through a productive and successful mediation without having to go to court. Remember, come prepared and always mediate in good faith. A large percentage of family law cases ultimately settle at mediation, and we want your case to be one of them.